Hello, I'm going to take this time to make a video about the last step in a writ of garnishment in Washington State. If it's your first time here, my name is Johnny Boehner. We're the Garnishment Gurus. This video is going to be talking about a step called the motion for a judgment on answer of garnishee. As I said, this is normally the last step that is taken to the court to obtain an order, a judgment on answer, usually called just a JOA, that will direct the garnishee, the employee, the employer or bank, as whatever it might be, to pay the money that they have withheld as a result of a writ of garnishment. This is the court's opportunity to kind of make sure that the judgment creditor, the judgment creditor's attorney, has checked all the boxes that need to get checked. What the court is primarily going to be looking for in most circumstances is whether or not the judgment debtor has been given an opportunity to contest the garnishment process, that they've been made aware of what rights they have by being provided a specific statutory set of documents that describe what those rights are, and whether or not there has actually been any contest for it. Those are the big things from the debtor rights that the court's going to be looking for. And then kind of administratively, what the court's going to be looking to double check on is that the judgment creditor sent out the writ of garnishment properly, that it was actually answered by the garnishee, and that's going to be from the bank or the employer that's saying, hey, we're holding this much money. In the case of an employer, it's 2 answers because it's a continuing lien, meaning it applies for a period of 60 days. A bank garnishment, of course, only takes for the money that is in the bank at the time. Generally speaking, courts aren't going to be examining the entirety of the answers in great detail if the debtor has not come forward to contest it or the creditor hasn't come forward to contest it, because either party can, of course, contest what the garnishee says. But by and large, what the court is going to be looking for is that the debtor's rights have been accounted for, and that whatever relief the judgment creditor is seeking matches what the garnishee says. So if the garnishee says they're withholding $5,000, the judgment creditor needs to only be looking for an order for $5,000. The process is almost universally done through ex parte, meaning it is sent in through the clerk's office. There's not a formal hearing where the attorney will appear and argue in front of the judge. It's a paperwork matter. Once this paperwork is all submitted, you can, in most courts, get a response within a week. And once you receive that response, it's going to come in the form of a judgment on answer in order to pay. And that JOA is going to get sent to the garnishee, who will then make the payment either directly to the judgment creditor's attorney or to the court. That could take a minute. You know, these are employers, and banks that might have other things to do. So it might take them a couple of weeks to make that payment. Once that payment is made, then if it goes to the court has to get it, process it, maybe wait, and then they're going to send it out to the attorney. If the payment goes straight to the attorney, or when the attorney gets it from the court, most attorneys are, depending upon the agreement with the client, are going to deposit those funds into a trust account. Then the attorney needs to wait about 3 weeks before they can send those funds out to the client, the actual creditor. And there'll typically, depending upon the law firm, of course ours does this, there'll be an accounting provided so that the creditor knows how much money they're getting. Back to the judgment on answer in order to pay. It is a very important step, but sometimes what happens in the writ of garnishment process is the employer, very rarely is it a bank, but an employer will start sending checks on a regular basis directly to the attorney. That's acceptable, although it's not correct. I would estimate about a quarter of the time that's how it occurs. You still have to go through the finalization process because those funds are coming. They are treated as an answer, just like a normal formal answer of garnishee would be. And so even though payments might come in, you still really need to wait until the court gives the authority to disperse them out Once the garnishee makes those payments, the garnishee is discharged. They no longer have any responsibilities. They've paid what they have to pay. Also, as part of the finalization process, which is internally what I usually refer to submitting the motion for judgment on answer, there is additional cost and attorney fees that are awarded against the judgment debtor, and so that can add up because the cost typically are about $400 once you include the attorney fee provision in there, which is always set at $300, just because that's what the law limits it to. Not that any attorneys are really charging $300. So once those costs get factored back into the judgment, they're added back onto the judgment. There's not a new judgment created. It's added to the existing judgment. That wraps up the garnishment process. In many instances, by the time this finalization process is commencing, it's already, the next round of garnishment has already began. And the reason for that is once you receive a second answer to a writ of garnishment from an employer, you know how much has been withheld, but you can't do anything about it because the judgment debtor is going to need a period of time, give them about a month, generally speaking, to account for mailing before you can submit the motion for a judgment on answer. But in that month before you can submit the motion to the court, it is still possible to start the next round of garnishment based upon how much money had been paid from the first round or the 17th round. This is sometimes the case. All right, thank you.